gaps, these ambiguities. And yeah, it'd be nice for them to explicitly spell out everything that could possibly ever happen when that statute is. We know that's just not how the laws are written. So it is an ambiguity. It is a broader delegation than it otherwise would be if there was a definition for epidemic. But again, I think the question is it an unconstitutional delegation, unconstitutionally broad? And I would argue that it's not. So, and I'll try to wrap this up.
No, I'm not trying to place any time restraints on you. I just want to be aware of my other hearing as well.
Okay, so moving on to section 20C, the provision that provides this is upon a determination by the local health department that an imminent danger to the health or lives of individuals exists in the area served by the health department, the health officer must danger. Initially, importantly, imminent danger in the public health code, and this really reference basically the officer not having a sort of live rationale for taking any action. I don't know if it was the context of this provision, but baked into 24.1, it actually says the order that the health officer puts in place has to incorporate the findings of the health department and must require immediate action to address the independent danger. So there is some rationale for this this type of order can be put in place. And as the court noted, this isn't something that the health department can call compliance. They have to go to court to do that.
Well, let me ask a question on that, Garrett, because I'm sure you've read in section 2443. As I interpret the entirety of all of these sections, are all within either the 2450s or the 5201. 333.2443, as I read it, indicated that a violation of a regulation or a rule is punishable as a 180-day misdemeanor and a fine. My question is, first, is there a tension between the section 2451 that says, because I was questioning Mr. Delaney about previously, that says if there's enforcement sought by the department, they have to go to the probate court, and then there's notice and opportunity to be heard. Is there tension between section 2451 that says that citizens have the right to be heard in the probate court, and 2443 that says any violation of a rule or regulation is a self-misdemeanor?
No, I don't think there's any tension there, because I think what we're dealing with are two different, we're kind of a civil remedy for the department to go to the court and say, they're not complying voluntarily, we need to tell them to comply.
Under 2451.
2451, and then the power that the others is referencing. I don't know who that would fall to. It would fall to some prosecutor, whether it be the Attorney General's office or the county prosecutor. We're talking about criminal penalty there, and that's not something the health department, that doesn't fall into their purview at all. So,
well, that's the exact statute that was cited in 2253 and the closure order for Mayor Pig, that's challenged here, right? To the threat of jail if there's not compliance.
That may have come from the state, but again, my focus was on what the local health officer did, and that was not cited at all. As Your Honor noted, it was just 2453 and 2451. Those were the only statutes that were cited in the local health department.
So there was no threat of jail in the local health department notice to the Iron Pigs?
I can tell you that. I could look at Exhibit A to the complaint.
To the complaint or to
the complaint. Yeah, Judge, I see no record of misdemeanors, criminalities. It's 24.1, 2453. There is a 29.2113 of Michigan's food laws. Nowhere cited is there any threat of a criminal penalty, which I would argue to the court that that's not a threat to the health department. And maybe they could have made everybody aware that, hey, this may happen to you, but it's not an authority that the health department had. I mean, they could have brought up criminal charges on the day.
Well, the health department acted by it through the Attorney General's office in the state of Michigan. Certainly has an authority.
Sure, yes, but it's not something this local health department would do, and it's not something they threaten to do in this case either.
Would do or could do?
I guess that's what they can't do. I don't think they have the authority to and I would fall to whether it's a county prosecutor, Attorney General's office. That's apart from 2451. It's something to involve compliance. They're trying to convey this is a civil rule remedy of compelling compliance, not putting in the jail.
I see a lot of the focus on the inner question case the reason, part of the reason that they found the delegation so broad and not capable of being salvaged is because it involved not only civil but also criminal penalties. Isn't that part of the reason that they sort of questions?
I did. I didn't read that to be the focal point of either of those decisions. I think what they're really focusing on is the broadness, the geographic broadness of the delegation of authority statewide, as opposed to what we're dealing with here being local within a couple counties.
I think you're taking off track. So
No, that's okay. Getting back to 2451, just very briefly applying those intelligible principles factors is going to be a common theme with all these statutes, but it's limited in geography to the territory of the health officer. I would argue that the definition of imminent danger is as precise as it can be. Again, is not going to be able to formulate a law with no gaps in accountability. There has to be some discretion to the executive when and again, there's a safeguard there that requires the health department to behind issuing this type of order on 2451. I think when we apply the same intelligible principles that we talked about, again, common theme, limited in geographic scope to the territory of the health department. I think the language is as precise as it possibly can be. And again, this is another scenario where if you want to compliance, you have to go to court, where someone could raise a challenge to the basis of that order, potentially avoid compliance altogether. The final two provisions, and they were raised together, so I'll analyze them together. It's 5201 and 5203. That's that situation we're talking about where the health officer can issue a warning notice to require a person to cooperate with the health department upon the determination that the person, quote, is a carrier and is a threat to others. So both carrier and health threat to others are defined in the Public Health Code. Mr. Gillen, in reference to, there's a requirement that if someone is found to be a carrier, the notice may require them to participate in education, counseling, and treatment programs and undergo testing. And some pause there too, because I think Mr. Gillen takes issue with the idea that the local health officer can reasonably assume someone to be a carrier of a disease. And I would argue that any higher standard is completely unworkable without this provision allowing him to compel someone to test. And importantly too, this isn't a scenario where someone is sequestered and has a contagious disease. Then they wouldn't be a threat to others. So this isn't that type of scenario we're talking about here. We're talking about someone who is out in the public, who believed to be a carrier of the disease, who believed them to be a threat to others. And that's a situation where the health officer can then issue a notice. Another scenario where they have to go to court to compel compliance, but then they would be able to confirm that person's status as a carrier. So, again, applying those intelligible principles, standards, limited in geographic scope, and not only geographic scope to the few counties that the local health department covers, but also more precisely to people who are carriers and threats to others. That's a very, 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 very narrow subset of the population that we're talking about here. So it's very limited in scope as to who it impacts. It's as precise as it can be under this situation. And again, this isn't a scenario where it would compel anyone to leave the home and be tested. If someone wants to languish at home with a contagious disease, they're free to do so under this provision. That's not what this is aimed at. So, what I'll do, Judge, I understand that the cases that I cited from Wisconsin, Indiana, Washington, Virginia, and Mexico, they're just persuasive authority on this court. And just in the interest of time, I know the court does have some things. I'm not rushed, but I do think it is an area that I think perhaps just breeze over. But I do think that those opinions pretty consistently upheld the type of language that's being challenged here. This, what's reasonable, what's necessary, looking at the scope of the delegation and taking into consideration things like the local health officer's qualifications. So
is that just because, like Michigan, the non-delegation challenges have not risen up to those higher courts yet? We have benefit now of the associates finding on the for good or for bad, same with any certified questions. So the fact that they haven't challenged yet, perhaps it's just because it's not far enough past the pandemic.
Well, so in some of these cases, like in the Wisconsin case, the court did have a non-delegation challenge in front of it and rejected that challenge. Very, very similar, I mean, eerily similar language, where it allowed the local health officer to, quote, do what is reasonable and necessary for the prevention and suppression of disease, including forbidding public gatherings deemed necessary to control outbreaks or epidemics. And that was a non-delegation clause. Challenge. That went to the Wisconsin Supreme Court. The court said in the context of public health, the statute established an ascertainable general policy aimed at disrupting the transmission of contagious disease. Substantively restricting the local health officers and in doing so, they focused on reasonable and necessary. The Wisconsin Supreme Court said, yeah, that's good enough. I mean, because we see why we're saying that that's good enough in this context. Main considerations that Indiana, Washington, Virginia, Mexico took into account. And taking this in context, we need local health officers on the local level to have this kind of flexibility to respond to evolving crises. Because respectively, the alternate paradigm that the plaintiff is advocating for, it just will not work. What's going to happen, there's going to be an immediate logjam if we go to a legislative body and say, you know, the health officer's order expired after 14 days, can we get an extension? Some of these bodies can't even approve budgets or even agree on what local health measures are needed. And that's what's going to happen. It's going to go to these bodies and die. So these are the considerations that the other states have taken into account. This is desirable to have this level of flexibility. It's not limitless, as the plaintiff argues. So if we just in conclusion, I think what's happening here is it's a policy disagreement that the plaintiff is trying to constitutionalize. They don't like the order, and I'm sure they're not alone in that, and I don't want to ignore the hardship that Mr. Murphy had to undergo, and business owners all over the state had to undergo during COVID. But if we apply the principles that we've been given from our higher courts and intelligible principle standard, these statutes clearly pass muster. Could they have been more precisely drawn? Perhaps, and that would have been ideal, but then it would have potentially limited the local health officer's ability to respond in times of crises, which I think would be bad public policy. But again, anyone who's unhappy with the way the public health code currently reads, they're not without recourse. They can lobby their legislators. They can run for office themselves. They can challenge anytime they're subject to one of these orders under the substantive process clause or any other basis they can find to challenge those orders. So I know this isn't less on the court, and please don't take it that way, but I wanted to highlight the fact that these provisions serve a very, very vital public health function in the state. And wholesale invalidation of the provisions that are cited in the complaint will have dramatic consequences and will quite frankly leave health departments and health officers absolutely powerless to control the next epidemic when it inevitably comes. So that's all I have, Judge.
Mr. Ross, I'm interested in one final question I've got for you, which is, you came across and gave a New York Times article recently on this case by Paul Lewitskind. He quoted you as having said a couple of things. So first, I'm interested in whether you cited it, and if so, what you meant by it. So Mr. Lewitskind had quoted you as saying that you know that the health department is facing an uphill battle. Was that your quote?
Yeah, that was my quote.
Why are you facing an uphill battle?
Because I did go on to say that I know we're very fair and you look at this with fresh eyes, but I get
the entirety of the article.
Right. So the only thing I meant by that was I get the appeal of just looking at T&D associates and saying 2253, 24, 53, 2253, 24, 53, they're almost identical. So that's an easy conclusion. They're similarly deficient. I never interpreted your comments to say that in the previous case, but that was certainly a focal point in the complaint. This is sort of implication that it's going to be an easy argument because look what the court's already done. So that's what I meant when I said it was an uphill battle, but I also said in an article, I think I've put ample reasons in front of it why this should be treated differently and why different outcomes are warranted.
Thank you, Councilman. Mr. Lane, any need for a brief rebuttal?
Very good, Judge.
Let me just double check. We've not had any full check-in.
No, Your Honor.
The court cited, and I was looking at phones, 333-24-37. And it has some verbiage in there that I must say I was not alerted to initially. Very short section. The department, that's Lansing, in addition to any other power vested in it by law, may exercise any power vested in a local health department. And it does not have that additional language about, does not meet the requirements of the act. But I would say that the state health department and the local health department has no power vested in it under the Michigan Constitution for law writing. They have other powers, enforcement, but they do not have law writing powers. And I think it's very interesting language that it must be vested by law. Twice that's in there.
Doesn't that undercut your argument that 2437 somehow creates a bigger geographical area than the state can match onto?
Correct, but the state health department, quite frankly, is going to argue we are vested with that power. And it's going to take me time to get to court to argue that. But I think that if the non-delegation statutes that we have gone through today are struck down as unconstitutional, then I'm not concerned at all about 2437, because the state and the local health departments will have no power vested.
Thank you. Mr. Remote. Our council, I think your briefs and your oral argument today. Self-track, I think, yeah, I like to find my, this is important to each of the parties enter this court. I'm going to issue a written opinion. I'm going to attempt to my best to be brief, unlike I was in the last big case, and also to the opinion how quickly that is, I don't know for sure. But I'll get a copy to each of the attorneys. Thank you both for being here. Thank you everyone for the public who's got interest in this case as well.
Thank you, Mark. Thank you, Eric.